Good afternoon, everyone, and welcome to the 2021 Occupational Health and Safety Year in Review. Thank you for joining us. My name is Shane Todd. I'm a partner in the National Labor, Employment, and Human Rights Group. I'm joined today by my partner, Rosalind Cooper, here in Toronto. I'm also joined by Richard Savage, who is counsel in our Vancouver office, Cathy, Chandler, who's an occupational health and safety consultant and paralegal, and David Marchione, who's an OHS consultant and paralegal, both in Toronto. Before we begin, I have a few housekeeping notes. There's an online survey at the end of the webinar. Please click the survey button underneath the video window. These surveys help us determine future topics, and your input is greatly appreciated. The materials for today's webinar can be accessed by clicking on the materials button under the video window. We're also recording today's webinar, and that can be accessed via the materials button. Oh, sorry, no, it can't. It can be accessed after the event. We'll be emailing out a link. If you have questions during the webinar, please submit it via the chat box. We'll do our best to answer all of your questions at the end of our presentation. We now have a closed captioning feature available. If you'd like to turn this feature on, please click on the CC button in the bottom of the video window. If you need technical support in the course of the day or our presentation, please click the tech support button and one of our technicians will be happy to help you. Finally, if you're looking for COVID-19 specific information, and I know many of you are, we have a wealth of information on our COVID-19 Knowledge Center, which you can find at Fasken.com. With that, on to our presentation. On the next slide, you'll see our agenda for today. We'll talk a little bit about vaccination policies before moving into a discussion of some noteworthy cases and sentencing trends. We'll talk about remote work, because that's basically what people are doing nowadays is remote work, and the occupational health and safety considerations that you need to be aware of. We'll pivot to talk about some regulatory changes in Ontario and in the West, and we'll also give you a workers' compensation update. Finally, we're going to save as much time as we can for some questions and answers. On to our first topic, which is vaccination. In advance of our seminar, we asked people for questions that they wanted answered. On the next slide, you'll see we got lots of questions, and a lot of them, more than a dozen, were about vaccination policies. Whether that's because of an emergence of new variants of concern like Omicron or rising case counts, I don't know. But clearly it's something that's still top of mind for employers. And when you're thinking about vaccination policies, whether they're mandatory or whether they're some shade of vaccination and test, there's a lot of questions and some answers that we'll give you today. You'll be thinking about what is the legal basis for your policy? Is it something that's required by law, regulation, directive, or order? Employers in some industries or sectors are now legally required to have vaccination policies. Now, those aren't always mandatory policies. Sometimes there's an option to submit to regular testing if a person chooses not to be vaccinated. For example, there's a directive under the Health Protection and Promotion Act in Ontario that says public hospitals have to have a policy requiring employees, staff, and others to provide proof of vaccination or a medical reason for not vaccinating or complete a vaccine education course. And for people who are not vaccinated, they have to go through regular testing. Similarly, in the federally regulated air, rail, and marine transportation sectors, employers are now required to have vaccination policies. And earlier this week, you will have heard the federal government announce proposed regulations under Part 2 of the Canada Labour Code to make vaccination mandatory in federally regulated workplaces by early 2022. You'll also know if you're in Ontario that many public health units have recommended that employers implement workplace vaccination policies. If you're not in one of those industries or sectors where it's mandatory, you'll be thinking about whether your OHS obligations can justify imposing those policies. Every piece of health and safety legislation across Canada has a general duty that requires employers to take reasonable precautions to protect the health and safety of workers. And COVID is a risk. It's a hazard to our employees and something we need to keep them safe from. So you'll be thinking about the measures you already have in place, masking, hand washing, enhanced cleaning or disinfection, and whether or not that's sufficient or whether something more is required as a reasonable precaution to protect your workers. And we'll know that when we're thinking about what else might be reasonable, that the balance of scientific and medical information we have currently tells us that vaccination is the best defense. When you have grappled with the basis for your policy, then you're going to turn to the practical. How is your policy going to apply? Who is it going to apply? How are you going to balance the different rights and interests at place here? How will you accommodate people who cannot vaccinate for protected grounds under human rights legislation? And what are you going to do with people who refuse to vaccinate without a protected reason? We're going to go through some cases today that talk about how courts and arbitrators have been approaching these issues. On the next slide, you'll see that we saw early support for mandatory vaccination in the case law. In Saskatchewan, an application to prevent Saskatchewan's proof of vaccination policy from going into place was filed against 4 Crown corporations and the province's Attorney General. And it alleged that requiring proof of vaccination to access certain venues was a breach of charter rights. That was dismissed by the court. In BC, there was a similar requirement for people to show proof of vaccination for access to certain non-essential events and businesses. A human rights complaint was filed by a complainant alleging that he was being discriminated against based on disability. That was dismissed. He did have a disability, but he couldn't connect his disability to his choice not to vaccinate. And the tribunal in that case said, your ideological opposition or distrust of vaccination, that's not enough for human rights protection in this particular circumstance. We've also seen in family law disputes that judges have decided that vaccination is in the best interests of children. On the next slide, you'll see that in Ontario, we've had sort of a rise and fall of court applications seeking to prevent employers from implementing mandatory vaccination policies. These have largely been unsuccessful. The first one was filed in relation to University Health Network, or UHN. They had implemented a mandatory vaccination policy that required everyone to be vaccinated or face termination if they weren't entitled to accommodation on human rights ground. A group of unionized and non-unionized employees filed a court proceeding to try to stop the employer from implementing it. A judge granted that order temporarily, primarily so that he could get more information about what was being alleged here. After hearing submissions from the parties, the judge decided to remove that order. For the unionized employees in that action or that proceeding, he said, the essential dispute here arises out of a unionized workplace, and it's about the employer's right to implement policies. It's essentially arising out of the application and interpretation of your collective agreement, and it should be dealt with through arbitration. And so he stayed that portion of the proceeding. For the non-unionized employees, the judge decided that there wasn't any irreparable harm that was going to result to these employees. Yes, they might be terminated for contravening the policy, but that wasn't irreparable harm. The court could compensate that through damages, and so it was dismissed. More recently, Canada Post implemented a mandatory vaccination policy, which required employees to attest to their vaccination status. And if they were either unwilling to be fully vaccinated or didn't attest to being fully vaccinated, they were placed on unpaid leave. The union brought an urgent cease and desist application to an arbitrator, and it was essentially a similar process to what we would see in a court proceeding. The arbitrator said, I'm not going to grant that cease and desist application. He decided that the balance of convenience favored implementation because of the important safety considerations at play, and also felt that there was no irreparable harm from the policy. One of the things that's particularly noteworthy in that decision, and there are lots of things, is that the arbitrator accepted that rapid antigen testing isn't an acceptable replacement for vaccination. Vaccination was the most effective means of accomplishing the important health and safety objectives of that policy. That Canada Post decision follows an earlier TTC case that you'll also see on the screen, where a Superior Court judge decided similarly that the balance of convenience favored the employer. They had a health and safety interest in mind, and the balance of convenience favored implementing that policy, and that reducing the risk of COVID-19 in the workplace was warranted. On the next slide, you'll see some trends we have from these cases. Essentially, the union challenges need to be decided in arbitration. Loss of employment is not irreparable harm. When we're talking about mandatory vaccination, we're not talking about forcing people to receive medical treatment they don't want to. People still have the choice to make decisions about that. But choices have consequences, and in this, the consequence may be losing your job. But your loss of employment isn't irreparable harm. An arbitrator or a judge can award damages, and in a unionized context could reinstate you if the policy is not warranted. Generally speaking, also, the balance of convenience has favored implementation of a policy, particularly where there's a provable safety justification underlying the policy. All of these decisions deal with policies before we get to the merits of them. We're looking at preventing employers from implementing policies and not whether or not the policies themselves are sound. On the next slide, you'll see some cases we have had dealing with the merits of the policy. When we get to these cases, the results have been more mixed. Can I get the next slide, please? Thank you. The results have been more mixed, and that might seem inconsistent, but I think it really just underscores how important the facts are and how important the context are to what the ultimate outcome of the decision is. The first case is Paragon Protection Limited. Paragon employs security guards, and they send them to work at client sites. And many of those clients had implemented mandatory requirements that contractors on site be vaccinated. Now, in response, Paragon implemented its own policy requiring its people to be vaccinated. The union filed a grievance, and that grievance was dismissed and the mandatory vaccination policy upheld. This case is a little bit unique, not only because of the type of work that these employees do, they're going to a third-party workplace to do their work, but also the collective agreement between the parties was specific in requiring employees to be vaccinated where either the law or a condition of contractor access required vaccination. And so in those particular circumstances, an arbitrator decided that the vaccination policy was reasonable and should be upheld. You'll see on the next screen that the arbitrator decided this policy is consistent with human rights legislation. It's consistent with your collective agreement that is specific to requiring vaccination. And it was a reasonable precaution in the circumstances to protect employees. If we move on to the next slide, you'll see that it hasn't always worked out in employers' favor. There was a case involving the Electrical Safety Authority. They had originally a voluntary policy where you could either vaccinate and provide proof of vaccination or test, and that policy seemed to be working relatively well. The union didn't challenge that policy. The employer hadn't had any outbreaks. The employer then decided to introduce a policy that everyone needed to be fully vaccinated, subject to accommodation under the Human Rights Code. And they did that without any apparent assessment of increased or changed risk that justified that change. The union filed a grievance, and the arbitrator was looking at whether or not this unilateral imposition of a policy was consistent and reasonable in the circumstances. And you'll see on the next slide that the arbitrator determined that it wasn't reasonable in this particular case. The arbitrator said that in workplace settings where risks are high and you have vulnerable populations, then mandatory vaccination might be reasonable, and it may also be necessary and required. But in workplace settings like this one, where employees can and were working remotely effectively, and they had a collective agreement right to continue working remotely, where there had been no outbreaks, no significant infections or other risks, and where there had been no interference with the employer's operations, because people were being refused site access or they couldn't travel for their job, where none of that was happening. It wasn't reasonable for the employer to pivot to a mandatory vaccination policy. You'll see at the next slide, the arbitrator was careful to say that this shouldn't be viewed by those who are opposed to vaccination as a clear win. And the arbitrator also said that this is very context specific and this is a unique and evolving situation. And what I've decided is unreasonable now may not be the case in a future proceeding in a different workplace. Moving on to the next slide. This is a case involving Ontario Power Generation. So the two cases we just talked about involve mandatory vaccination policies, one where they were upheld, one where it wasn't upheld. This is an employer who decided to implement a vaccinate or test policy. The arbitrator in this case decided that testing unvaccinated employees was reasonable in the current circumstances. It's a global pandemic, and it was reasonable in light of an employer's duty to take every reasonable precaution to protect workers. The arbitrator said it wasn't reasonable for the employer to require the employees to pay the cost of their own testing. It was the employer who required the testing to be done, and they should bear the cost of the actual test. The employer in this case wasn't required to pay the employees for testing time. The testing was done at home, took about 15 minutes, and it was relatively quick. The employee could go about their day. The arbitrator said it's reasonable that you don't pay employees in those particular circumstances. Plus, the arbitrator said that, if you're paying for that time, it might actually de-incentivize people getting vaccinated because they would get additional paid time if they weren't. The arbitrator also said it was reasonable to suspend people who refused to be tested, who refused to be tested and who were also unvaccinated. The arbitrator said it wasn't a breach of the disciplinary process in the collective agreement. Rather, those employees who were refusing to test were failing to take the reasonable and necessary step of showing that they were fit to work. And unlike in a discipline case, they always had control about when they wanted to come to work. All they needed to do was test. On the next slide, you'll see a quote from the arbitrator. This wasn't a discharge case, but the arbitrator hinted that employees who refuse to test and are fired are likely to have their terminations upheld at arbitration. He believed that effectively they would have made a decision to end their career with the company by failing to comply. Those cases all have come from Ontario. We know there's another case arising in Quebec where a group of unionized cleaning companies asked an arbitrator for a ruling on whether or not they could require their employees to disclose vaccination status because it was a condition of their contract with third-party clients. The cleaning companies had to collect vaccination status of their employees who were assigned to those contracts and sort of validate to their clients that they were, in fact, providing vaccinated staff. And failure of the cleaning company to do that could have resulted in termination of their contract, which would have resulted in employees being laid off. And the arbitrator said the employer clients, the ultimate employer clients of the cleaning company, they're entitled to impose vaccination requirements on subcontractors because of their health and safety obligations. And a vaccination requirement is justified in order to reduce the risk of COVID-19, and that unvaccinated individuals present a risk to themselves and to others and are in principle in breach of their health and safety obligations. And so while we may be infringing on people's privacy and their physical integrity by asking them to be vaccinated, it's justified and it doesn't infringe the Quebec Charter. The risk of being infected was far greater. The health risks to these individuals was far greater than asking them to disclose a portion of their private life, their vaccination status, that is. And so the arbitrator said that that was a reasonable thing. If you look on the next slide, you'll see that it ultimately comes down to, in many workplaces, a question of reasonableness. Because you're unionized, arbitrators are looking at reasonableness when assessing, unilaterally implemented policies. And if you're not unionized, you're looking at whether it's a reasonable precaution. There's some questions on the screen, which are sort of a non-exhaustive list of possible questions to consider when you're thinking about whether it's reasonable in your circumstances. Is there some hazard to be controlled, or you're working with a vulnerable population or with the public? Have there been workplace outbreaks or community outbreaks that need to be controlled? You'll be thinking about what the efficacy of your current measures are, your masking, your screening, your cleaning. How has that controlled the risk of COVID transmission in your workplace? Has something new arisen or changed that makes it necessary for you to adapt and do something more? Is there an operational necessity or impact? Are you working with third-party clients who require vaccination for site access, or do you have employees who travel by air who are required to be vaccinated to travel by air? Are there operational impacts at issue? And more fundamentally, has the law changed? Are you required or recommended by regulation, by law, by order to have a vaccination policy? And thinking about those things can help you determine whether or not vaccination is reasonable in the circumstances of your workplace. I'm going to leave the mandatory vaccination portion of the presentation now and move on to a section that Roz has on noteworthy cases in sentencing.
Thank you very much, Shane. My section of the presentation really deals with looking at some recent cases that emerged in 2021 and what that means in terms of occupational health and safety requirements and how you manage potential exposure to liability. If we could start with the first slide, I'm going to focus primarily for this first section on a recent decision that came out involving the city of Sudbury. And this case is an important one because it looks at the constructor-employer relationship. And oftentimes, many companies that are involved in construction projects struggle with the different workplace parties and how to allocate liability and responsibility amongst those parties. We have employers, we have constructors, we have owners, we have supervisors, we have workers. And oftentimes, a particular company may be concerned that they're stepping into multiple roles during a construction project. There have been several cases in the past that have looked at the relationship between different parties and how to allocate responsibility. And the city of Sudbury is one of the cases that adds to the jurisprudence that exists in this area. And it's a very important case, not so much because, in my view, it changes the existing case law, because it really emphasizes the obligations that employers will have and how easy it is to be considered to be an employer, even in a context where you don't have a direct relationship or involvement in the project. So let's talk about the background and the facts. So in this case, the city of Sudbury had hired a general contractor to undertake road and water main repairs. And the construction contract was your typical construction contract. It identified the general contractor as being the constructor for the purposes of the OSHA. And as many of you know, that's very standard to see where the responsibilities for the constructor obligations under the OSHA are allocated to the general contractor who performs that function. And this was generally understood to mean that that general contractor was the party that had primary responsibility for health and safety on the project. In September of 2015, a pedestrian that was walking through the construction zone was fatally injured by a road grader that was being operated by an employee of the general contractor. The Ministry of Labor investigated, and they found that at the time of the accident, there were various protective measures that had not been employed. And these included separation fencing to keep pedestrians out of the work area and away from the construction equipment, a paid duty police officer to control and direct traffic, and a signaler to communicate with the grader operator. And so the ministry decided to lay charges. They laid charges against both the general contractor and the city, referring to various violations of the OSHA and the regulations, the construction projects one specifically. And it should be noted that the city was actually charged for two workplace roles. They were charged as a constructor, despite the fact that there was a general contractor, and also charged as an employer. And the general contractor, who was also charged, was ultimately found to be guilty in a separate proceeding, but the city pleaded not guilty. If we could have the next slide, please. So when the trial occurred, the trial judge found that the city wasn't either an employer or a constructor. That was the initial view, and held that there were no duties on the city whatsoever under the OSHA. And they also found that if that was wrong, they felt that the city had provided a decent due diligence defense and had made out their obligations to show on a balance of probabilities that they had been duly diligent. And the decision was appealed by the Ministry of Labor. And on appeal, it was upheld as well. But the Crown decided to appeal to the Ontario Court of Appeal and argued that the previous decisions of the lower courts had erred in finding the city was not an employer under the OSHA. So the appeal specifically focused on the employer relationship, not the constructor relationship. And so if we can go to the next slide. The real question for the Court of Appeal was a simple one, which is the city, in the circumstances and the facts that I described, considered an employer for the purposes of the OSHA? And they looked at the definition of an employer, which is set out on this slide, and which is one that many people are familiar with, and commented on how broad and expansive that definition was. And they also commented on something you'll see in many decisions that come up from the courts, especially the Court of Appeal, which is that the OSHA is a public welfare statute. It has to be interpreted liberally as opposed to narrowly or technically in order to fulfill its purpose. And we've seen a number of decisions, including City of Hamilton decision and other decisions that have relied on it, that will look at the OSHA and say, you can't give it a narrow or strict reading. You have to give it a broad interpretation that looks at the purposes of the statute. And so in considering this, if we could go to the next slide, please. The Court of Appeal focused its attention on that first branch of the definition and said that there was no doubt that city inspectors were on the construction site at different points in time, performing a variety of tasks, including things like quality control, progress monitoring, and general contract compliance. But they said that it really didn't matter because they felt that the city felt within that first branch of the definition of employer. And it referred back to an old decision that many of us have turned to on many occasions called Weisen in 1992, which was an Ontario Court of Appeal decision that involved a death of a window washer, where the company that had subcontracted with another to provide employees to do window washing was charged as an employer. And in that case, they were also determined ultimately to be the employer. And the Court of Appeal emphasized that nothing has changed since that decision came out back in 1992, and that it is very common to have overlapping responsibilities in a workplace where you have different parties either exercising multiple roles or the same, or multiple parties exercising the same role, and that you have to look at what will ultimately protect health and safety in the workplace. And in deciding that, they said that a person can be an owner, a constructor, and an employer all at the same time and have all of those obligations if that applies in the particular circumstances of the case. And so in this case, they concluded that the city was an employer within the meaning of the Act, and therefore it was liable for violations of the regulation that had been found by the trial judge unless they could make out the due diligence defense. Now, because the Crown in this case had also appealed the trial judge's determination on the due diligence point, the appeal was allowed and remitted back for trial on the question again of the appeal of the due diligence finding. So that is still out there, but the main point from the decision, and something that's important to emphasize for those that are involved in construction projects and hiring others, is that the simple fact that you are the owner of the project and you contract with a general contractor to be the constructor of the project does not mean that you avoid your obligations as an employer. You still have to look at the obligations that exist under OSHA and comply with those obligations as an employer and exercise due diligence in those circumstances. And you otherwise will be found to have been in violation if you can't demonstrate due diligence. Again, from my perspective, I say this doesn't change the case law. It's no different than what Weisen said back in 1992, but it's an important reminder from the highest court in Ontario that as an employer, you must have a proper due diligence system in place because you will not be able to avoid being found to be the employer in these circumstances. Go to the next slide, please. The next case that I wanted to talk about, which also is a case that came out this year and which looks at these relationships and roles in the workplace, is the case of GMJ Electric Inc. And before talking specifically about it, I wanted to go back over some of the decisions that have come out over the years that have looked at the definition of supervisor, because it really is interesting that there's been this evolution of case law that has said that you can be a supervisor when you are on site controlling what's happening. And you can also be a supervisor if you're up the chain back in the office and never even actually attend at the workplace. And I've often heard companies arguing, who is a supervisor in a particular set of circumstances? And I've heard the view, well, so-and-so isn't on site. And if they're not on site, they can't possibly be the supervisor. And then I've heard the other side of the coin, which is the argument, well, yes, this individual was on site, but how could they be the supervisor? They don't deal with things like payments. They don't deal with things like discipline or absences from the workplace. So they don't really have authority over the workers. So they can't possibly be the supervisor. And so I'm just going to do a quick run through of some of the historical decisions and then focus on the GMJ decision, which came out this year, just to give you a bit of a flavor of what it really means to be a supervisor and how very broadly it can be interpreted. So the first case that I've put up here is an old case from 2002, Atomaco, which some people may be familiar with, but it is noteworthy because it confirmed this objective approach to determining whether a workplace party is a supervisor. And it actually said that it really is somewhat irrelevant to the determination whether or not someone actually exercises control or authority. It really is the question of, do they have that authority and can they exercise the authority? And so it establishes one of the premises, which is, you have to use this objective perspective to determine whether or not somebody is a supervisor in the particular circumstances. And in that case, Mr. Atomaco, who was the president of the corporate employer, had employed another supervisor, and the court held that was irrelevant for the purposes of determining whether or not he was a supervisor. The next case, if we could go to the next slide, please. And I just have a little quote here that just summarizes what I've said with respect to the supervisory objective test. And if we could go to the next slide. So the next slide is a case involving Bartram, and I'm going to talk about that in a minute, but I want to digress just to talk about a case that I didn't put up there, but I think is important for people to know about, which is the Walters case, which unfortunately was my case, and I wasn't successful in that case. But in that case, it was the opposite of what we just saw. So Mr. Walters was actually employed by the City of Toronto, and he was an on-site supervisor, and I say supervisor in quotes, for two other workers at the workplace. He did not have authority to control payment of workers. He didn't have disciplinary powers. He was really simply somebody who was on site at the time directing who should do what amongst this crew of three people. And in that case, and it did go to the Ontario Court of Appeal, we argued it all the way to the Ontario Court of Appeal, they held that Mr. Walters was a supervisor and that you could be a supervisor simply because you were on site and telling people what to do and directing how the work is done, even if you don't have any of the other powers that you would normally expect a supervisor to have. So that's just another important one that shows the other extreme in perspective. But the one on this slide, which is Bartram, involves a situation where it was a superintendent at the TTC who was charged as a supervisor with 3 offenses under OSHA. And it involved a accident that occurred where critical injuries were sustained because of exposure to high levels of carbon monoxide while a crew of workers were performing repairs on a subway track. And at trial, one of the key issues came up was, is Bartram, a senior official in charge of a department with over 400 employees, a supervisor? And what the court looked at is, what are the responsibilities of a supervisor? Can it be imposed on someone who is in the highest level of management where you have a large multi-layer corporation? And, there was a good review in that case done of what does it mean to be a supervisor and how can you function in that situation? And what the court looked at is it talked about how none of the workers ever reported or got direction directly from Mr. Bartram. They said that he had delegated much of his authority. He never communicated with the maintenance crew. But at the end of the day, they found that he had ultimate responsibility for the workplace. So interesting, again, to look at these decisions that go back and forth between upper levels of a corporation down to lower levels of a corporation with respect to this issue. If we could have the next slide, please. I'm not going to spend too much time on this just because of a shortage of time, but I also wanted to make the point, this case pointed out that even a non-natural person could be found to be a supervisor for the purposes of OSHA. And this relates to the concept that everybody usually assumes that a supervisor has to be an individual person, that you cannot be charged as a supervisor if you are an entity. But this case is interesting, and I pointed out simply because it says that you could have a situation like this where you have an entity that's not a natural person actually being held to be responsible as a supervisor. So just something to keep in mind. Next slide, please. So turning now to the decision that actually came out this year, GMJ Electric, it's a very difficult case in the sense that the worker involved received significant critical injuries, ended up being losing both of his legs and being confined to a wheelchair as a result of this critical injury that was sustained during the construction of an addition onto a commercial building. And there was a general contractor involved who had subcontracted with GMJ, which was a small electrical contractor. So again, GMJ is the subcontractor to the main contractor on the site. And the work was carried out primarily by two workers that were employed by GMJ. And the incident occurred, and both the GMJ entity, the corporate entity, and the owner were charged with offenses under the OSHA. And the owner was charged as a supervisor with failing to ensure that the injured worker worked in a manner and with the protective devices and measures and procedures prescribed under OSHA. So the charge really focused on this failure of the owner as supervisor to do what needed to be done. And of course, the owner argued that there were various authorities on the site, including the contractor, including others from the subcontracting entity, and including a supervisor. And he was not the supervisor under the OSHA. And that was the main thrust of the argument. And one of his other key arguments was that he had specifically appointed another individual, a Mr. Moore, who he described as being his eyes and ears on the project to ensure that everybody functioned and operated safely. He also said he never went to the work site, he wasn't there consistently enough to be a supervisor, and he should not be held to be a supervisor under the legislation. Interestingly enough, at the end of the day, the court said you can have multiple supervisors on a site. You could have Mr. Moore, who is his eyes and ears on the site every day, being a supervisor. But you can also have somebody who is much more senior being a supervisor as well. And they held that the owner did fall within that definition. If we could go to the next slide, please. This just summarizes the conclusions from the court, but the key emphasis here is that you have to remember when you're looking at who could potentially be responsible for workplace obligations, who has to exercise due diligence. It's not just the individual on site. It's not just the individual back in the office that's sort of the lead at the top of the chain in terms of responsibility. It could be both, and it's important to ensure that both have a proper due diligence defense in the particular circumstances. The GMJ as the corporation and the supervisor both sought leave to appeal to the Ontario Court of Appeal, but leave has been denied. So the ruling stands as is. If we could go to the next slide. And so the summary at the end of the day is, as I said, to be cautious and to bear in mind that there isn't just one person that plays the role of supervisor, and to consider that in the context, even as the owner of a company who could be deemed to be the supervisor. If we could go to the next slide, please. So last topic I'm going to talk about very quickly, because I appreciate we're running out of time, is a bit of sentencing trends with respect to occupational and safety matters in Ontario. On this slide, I've got three matters, all of which involve fatalities. I focused on fatalities just to give you a sense of some of the range of fines that are emerging, because as you all probably know, that one of the key factors in sentencing from the Ontario Court of Appeal is to look at the severity of the injury sustained in the context of the incident that occurred. And so when you look at that spectrum of severity of injuries, critical injuries and fatalities are on the high end of that spectrum. And so I thought I would just give you a sense of what we've seen over the last year in the context of fatalities. I won't go through the particular facts in detail. You can read them on the slide. But I think what's important to note is that you will see quite a range, even where you're dealing with a situation involving a fatality. Now, mind you, in the first decision, the upper crust decision, you've got 2 workers being killed in separate incidents for which the fine was imposed. But what does drive the penalty, which is also from the Cotton-Felts Court of Appeal decision, is the size of the company. And the financial wherewithal of the company. So you can see in the context of a smaller company, you're going to be looking at a much smaller penalty versus larger companies that will face larger penalties. The last slide that I'm going to cover here, I bring up this decision. It's an old decision in 2018, but I often get asked about, well, what are the highest fines you've ever seen in health and safety? Everybody wants to know what the extreme case is. And I bring this case up because in the last 3 or 4 years, this is the highest penalty that has come out to date. And you can see from this slide, the fine was $1.3 million, which is a pretty significant penalty under the circumstances. I'm going to stop there and pass it along to my colleague for the next portion of the presentation.
Thanks very much, Roz. So I'm going to be discussing occupational health and safety considerations in the context of remote work. And we can go to the next slide. Certainly, work from home for many of us has become the new normal, and it's likely to continue past the pandemic. And it's brought forth some new occupational health and safety challenges for employers. In many jurisdictions, an employee's home may be considered an extension of the workplace if the home is where the employee is engaged in work for their employer. In those jurisdictions, requirements and duties that are set out in occupational health and safety statutes might apply, including general duty clauses, which require employers to take every precaution reasonable in the circumstances for the protection of workers. In other jurisdictions, like Ontario, for example, the answer is a little bit less clear. In Ontario, the definition of workplace is certainly broad enough to cover a worker working from home. However, Ontario's Occupational Health and Safety Act contains a provision that states that the Act doesn't apply to work performed by the owner, occupant, or their servant in or about a private residence. So to make matters a little bit more complicated, there's limited case law interpreting this exemption and not really a lot of meaningful guidance from the regulator. So we tend to recommend that employers take a risk management approach to health and safety to ensure that workers are not exposed to uncontrolled hazards while working from home. We can go to the next slide. So in terms of a risk management approach in the context of working from home, you want to consider what are the reasonable steps to ensure the health and safety of workers that work from home. Reasonable steps might include implementation of a work from home policy and program that includes a workplace assessment and ergonomic considerations, for example. But I also think that an important part of your work from home program would be to develop and implement reporting and investigation protocols to address incidents and accidents that occur when a worker is working from home or remotely. So first of all, workers should receive information and instruction to immediately report to their manager any incidents or other occurrences arising in the course of their work. And depending on the nature of the incident, so for example, is it a serious injury? Is it a critical injury? External parties might need to be notified, the OHS regulator, for example, or if applicable, your provincial workers' compensation board. So it actually is possible that a worker working from home would be entitled to workers' compensation benefits for an injury that occurs when they're working from home. Workers' compensation boards are essentially going to look at whether or not the incident occurred in and of the course of employment. And in terms of determining work-relatedness of an accident that occurs in somebody's home, the following factors are likely to be determinative. So first, whether or not the work-at-home employee was engaged in an activity for the benefit of the employer. So in other words, was the worker working when the accident happened? And an accident that occurs outside of regular work hours wouldn't necessarily disentitle an employee to workers' compensation benefits if the employer permits or otherwise condones a flexible work schedule. And it certainly might be difficult to determine whether the employee was working at the time of the injury. So another factor that workers' compensation boards will look at in determining work-relatedness is if the employee was doing something which is reasonably incidental to their employment. So if yes, that employee would likely be considered to be in the course of employment. And activities considered to be reasonably incidental to employment might include things like, coffee and meal breaks and traveling up and down stairs or throughout the home, to the extent that these activities are required for the purposes of the work-related activity or reasonably incidental to the work-related activity. Any activity that represents a distinct departure from the scope of the employee's job or employment would likely not be considered to be in the course of employment. So, for example, being engaged in activity solely for personal benefit, like taking a break to do laundry or to mow your lawn, for example, that suggests that the employee would not be in the course of employment. So I think this is why it's really important for employers to take steps to ensure that employees that are working remotely, working from home, that first of all, they know that it is your expectation that they report any sort of incident or accident to you immediately, just like they would if they were working in the traditional workplace. And also that an investigation is done of the circumstances surrounding the injury. So I'm going to jump now to the next slide and pivot a little bit. And I want to review Ontario's legislative changes that have come into effect in 2021. As well as some of the upcoming changes to health and safety legislation that are likely going to be extending into 2022. So on July 1st of this year, a new regulation came into effect under the Occupational Health and Safety Act. You can see the name of the regulation on the slide, Ontario Regulation for 2021. So the new regulation essentially streamlines the requirements for reporting workplace fatalities, critical injuries, non-disabling injuries, occupational illnesses, and other prescribed incidents. Basically, the requirements that are triggered by sections 51 to 53 of the Occupational Health and Safety Act. So these requirements have now been streamlined into this single regulation that applies to all workplaces covered by the Occupational Health and Safety Act. Whereas previously, the sector-specific regulations contained provisions with respect to the information required to be in a report to the regulator. Those provisions are now revoked, and reporting obligations, including the contents of written reports to the Ministry of Labour, Training and Skills Development, are relocated to this new regulation. As I said, the regulation applies to all workplaces covered under the Occupational Health and Safety Act. There is an exemption, however, the requirement to provide a written report or notice when a worker is killed or critically injured or disabled from performing their usual work or otherwise requires medical attention. It doesn't apply if the outcome was the result of a highway collision, unless the affected worker was working at a construction project at the time or the worker wasn't traveling in the motor vehicle at the time of the incident. And under Section 3 of this new regulation, employers must provide a written report if a worker is killed or critically injured from any cause at a workplace. So interestingly, this new section contains a key wording difference from the statutory notice and report requirements under the Occupational Health and Safety Act. As most of you are probably familiar, pursuant to Section 51(1) of the Occupational Health and Safety Act, an employer has to notify the Ministry of Labour, Training and Skills Development immediately when a person is killed or critically injured in the workplace, and then within 48 hours provide a written report. The new regulation, however, prescribes the required contents of a written report where a worker is killed or critically injured. So we might see some clarification at some point from the Ministry of Labour, Training and Skills Development on this difference in wording between the regulation and the Act. That said, the regulation doesn't eliminate the requirement under Section 51 of the Act to immediately report instances where a person has been killed or critically injured at a workplace, whether or not the person is a worker. The regulation also sets out some reporting requirements for certain prescribed incidents related to workplaces where the mines and mining plants regulation applies or the construction projects regulation applies, as well as workplaces where regulations with respect to diving operations and X-ray safety apply. And the regulation also sets out prescribed incidents where a written report needs to be actually supplemented with a report, an opinion report from a professional engineer stating the cause of the incident. So one example there is at a construction project where a worker is killed or critically injured. because of the collapse of a crane, for example. That would require not only a report to the Ministry of Labor, but that PNG opinion report. The new regulation also revokes Regulation 834, which, as most of you probably know, that's the critical injury defined regulation. It incorporates the definition of critical injury into the new regulation, and the wording of the definition of critical injury remains unchanged. And then finally, there's a new requirement to maintain copies of the written reports and notices that need to be sent to the ministry for a period now of 3 years, whereas it used to be 1 year. Moving on to the next slide. Another legislative amendment relates to the Industrial Establishments Regulation, Regulation 851 under the Occupational Health and Safety Act. Ontario Regulation 434/21 amends Regulation 851 to streamline and clarify the pre-start health and safety review requirements. So Section 7 of Regulation 851 requires that a pre-start health and safety review be carried out in factories, for example, on machinery, safeguarding devices, racking structures before they're operated for the first time, or before modifications are made. So with these proposed amendments, the equipment, protective elements, structures, and processes that need a pre-start health and safety review remain the same. However, the table in Section 7 that sets out the circumstances requiring a PSR has been modified to include a new column setting out exemptions to having to do a PSR. So most of these exemptions were actually already described in the body of Section 7. Some of the circumstances and exemptions have been modified to clarify their meaning, but there are two new exemptions. The first is related to item 1 in the table, which pertains to storage of flammable liquids. And then the second is related to item 8 in the table, which pertains to ventilation systems. And these changes come into effect on January 1st of 2022. And then going to the next slide, the last significant legislative change that I'm going to be discussing relates to tower cranes. On July 14th of this year, the Ministry of Labor, Training and Skills Development, they launched a consultation on improving health and safety requirements relating to tower cranes, and it aims to update current legislative requirements for the operation of tower cranes. The impetus for this review, I suspect, is in response to the numerous incidents with tower cranes across Canada in the last couple of years, with several collapses in Toronto and one this past summer that killed five workers at a construction site in downtown Kelowna, British Columbia. So the ministry's proposal, which is available on their website, includes 20 recommendations, and it targets sort of 6 key areas of focus. I suspect that based on what we know about some of these tower crane incidents, stakeholders are going to want to see amendments related to the mechanical fitness of equipment, potentially the need to retire equipment after a certain period of time, and likely more stringent requirements with respect to training. We're going to continue to monitor the consultation process, and at this point, it looks like it'll be extending into 2022. I'd like to pass it now to my colleague, David Marchione, who's going to provide a workers' compensation update.
Thanks, Cathy. So I'm going to speak briefly about a few issues with respect to workers' compensation that have come up over the past year or so. If we can move to the first slide, I just want to speak briefly about workers' compensation benefits and COVID-19 claims. I've been involved in a number of issues with employers with respect to COVID-19 claims. The question arises about why COVID-19 is treated as an occupational disease versus some other issues that are not. Most prominently the flu, and the answer that has been given by the compensation boards is essentially that the flu is a public health issue that recurs every year, and certainly while coronaviruses themselves are not necessarily new, the COVID-19 virus that we've been dealing with was new, was novel. Not a lot was known about it in terms of transmission, impact, et cetera, and it has been treated by the various workers' compensation boards across the country as an occupational disease, and entitlement under those pieces of legislation has been treated fairly similarly. In order for a worker to be entitled to benefits if they're diagnosed with COVID-19, it has to be shown that the nature of the employment, the worker's employment, created a risk of contracting the disease that was greater than the ordinary exposure risk to the general public. A number of compensation boards, including WorkSafe BC, have fact sheets, for example, that set out the types of workers that would likely fall into this type of category. People who work in care settings, if they're dealing with people who've been or treating people who've been exposed to COVID-19 or have COVID-19, would be an example. British Columbia is actually treating COVID-19 cases a little bit differently than the other provinces, as there is because of the notice of a public health emergency in that province, they're treating it with a presumption in that if it can be shown that, or if a person's employment does create that risk, that's greater than the risk to the general public, and they've been diagnosed with COVID-19, then it's presumed that the COVID-19 is due to a work-related exposure. That presumption can be rebutted by the employer, for example, if there's evidence that supports that the worker was not exposed to COVID-19 at work. So, for example, were there any other cases? Was the person potentially exposed at home from a family member, or were they not even at the workplace during the incubation period, for example? It's important to note that there is reporting criteria for these cases at the compensation boards. Employers are required to report cases of COVID-19 if the criteria are met. So if the person was likely exposed at the workplace, but more significantly, if the employee thinks that their COVID-19 is work-related, there would be an obligation to report. And certainly, if a report was requested from the compensation board, then there would be a requirement to report. The compensation boards each have jurisdiction to determine whether there is entitlement. It's not up to employers to determine whether something is work-related or not. So if a report is requested, that request should be taken very seriously, and a report should be filed with reasons why you may think that the condition is not work-related. Moving to the next slide. As COVID vaccines became more prevalent, the compensation boards issued directives and information about when and if workers would be covered if they had an adverse reaction to a COVID vaccine. The information that's been provided by the compensation boards is fairly consistent right across the country, in that workers may be entitled. It says may because it really depends on the facts and circumstances of the case. If they have an adverse reaction to the vaccine, and that adverse reaction should be beyond what would normally be expected in terms of a short-term reaction. When the short-term reactions include minor pain at the injection site, maybe a fever for a couple of days, or feeling unwell for a couple of days. But if a person has a significant adverse reaction and the vaccination was a mandatory requirement of their employment or continued employment, then they may be entitled to compensation benefits if they did in fact have an adverse reaction. So again, all of that information would be looked at by the compensation boards, and the compensation boards have been providing cost relief to employers with respect to both entitlement for COVID claims and for reactions to vaccines. So we're going to monitor that and see if that will continue for the long term. Ultimately, if a vaccine and getting the vaccine is entirely voluntary, then the worker may not be entitled to benefits. Next slide, please. Just briefly, there have been a few updates with respect to legislation, workers' compensation legislation across the country and significantly in the Western provinces. As of January the 1st, 2021, Alberta set out that it would be the compensation board would be able to review a worker's compensation benefit entitlement if that worker's terminated from modified work due to egregious conduct. So if the worker did something willful, if they did something intentional, contrary to policies, for example, your workplace violence policy, drug and alcohol policy, if that behavior was determined to be egregious, the worker may not be entitled to further benefits, because entitlement to benefits is related to a worker's wage loss due to the work injury. If the wage loss was due to their own misconduct, which resulted in them getting terminated, then their entitlement to benefits may end. That provision only applies to temporary benefits, and my understanding is that is because the change in legislation specifically states it only applies to temporary benefits and not permanent benefits should the worker be entitled. So we'll see if there's any changes that come beyond that, because that's only been in place since January 1st of 2021. Alberta also made some changes with respect to psychological entitlement for first responders, including correctional officers and emergency dispatchers. There is entitlement under the compensation legislation if a person has a psychological injury, either from a traumatic incident or due to chronic exposure to incidents that arise out of and in the course of their work. But as of the beginning of this year, 2021, January 1st, there is a presumption that if a first responder, correctional officer, or emergency dispatcher is diagnosed with a mental health issue after an exposure, it will be presumed to be work-related. That can be rebutted with other evidence. However, in my experience, that may be tough. As you know, I have a case currently with dealing with an emergency dispatcher who had no real prior history and then was diagnosed with post-traumatic stress disorder after a series of particularly traumatic calls on the same day and within a very short period of time. So the presumption applies, and it can be very difficult to rebut if there's no evidence to the contrary. So those are significant changes. Next slide, please. There were other additional amendments that came into play as of April 1st. The duty to reinstate under the workers' compensation legislation in Alberta was changed, and in its place, there were duties put into place for workers and employers to cooperate with respect to all aspects of returning to work. So that obligation, the obligation to reinstate, still applies for any claims with an accident date between September 1st of 2018 and March 31st of 2021. But for any claims as of April 1st, 2021, with the injury dates as of then, the duty to reinstate doesn't apply, but there would be joint obligations to cooperate with respect to return to work. Also, as of April 1st, 2021, employers do not have to contribute to health benefits that may have been in place, that's employment health benefits that may have been in place before the worker went off work due to a work injury, although they can opt to do so, but there's no specific requirement under the workers' compensation legislation. And then significantly, there was a change to the time limit to appeal decisions from the dispute resolution and decision review body of the compensation boards. That time limit was reduced from 2 years to 1 year for any decision after April the 1st of 2021. So it makes what it does is it puts the appeal window for the appeals commission in line with the appeal window for the dispute resolution and decision review body. So both of them are now 12 months. Can be significant if you've been dealing with workers' compensation claims for a significant period of time. Next slide, please. Just moving over to British Columbia for a minute, a couple of significant changes that occurred with respect to the implementation of Bill 23 that changed the Workers' Compensation Act. Specifically, typically in BC, workers' compensation benefits would end at the age of 65 or when the worker would retire if WorkSafe BC is satisfied that they were going to retire after age 65. Up until 2020, a determination of when that would be was made when WorkSafe made a decision about the worker's permanent disability benefits. However, as of January the 1st, 2021, WorkSafe is able to wait until the worker reaches age 63 before making that determination, using a more fulsome approach to determine when the worker is actually going to retire, to see when or when they intended to retire, in order to see when the end of their benefits were. Hopefully, for any claims that have been long running, this may not have any impact on an employer's experience rating, as the experience rating window is fairly limited. However, it may impact certain new claims if the worker was older at the time of the injury. And then finally, in BC, there was a change with respect to how a worker's permanent partial disability benefits are to be determined. The WorkSafe BC is going to be taking a more holistic approach. As of January the 1st, 2021, it can look at either a worker's loss of function, the degree of impairment based on the injury, or their loss of earnings, which looks at their earning potential based compared to their pre-injury earning potential, and then award benefits based on the greater amount or the amount that would be more beneficial to the worker. So that could have additional impacts for employers as well. Okay, next slide, please. In Ontario, the WSIB rolled out a change to its experience rating system as of January the 1st, 2020, revamped the entire system, and that system was set to be rolled in over a period of 3 years. Due to the pandemic, the WSIB changed the rollout of the system, and even though premium rates were established in 2020, it made no changes to employer premium rates in 2021. So whatever rate an employer had in 2020, it maintained the same rate in 2021. When the WSIB set the premium rates for 2022, it adjusted employers' premiums either up based on their experience rating or down based on their experience rating, but it limited the amount that it would adjust any employer's premium if it were going up. So the maximum increase in 2022 was limited to approximately 5%. That the maximum increase in 2023 will be limited to a maximum of 10%, and the program is set to be fully functioning by 2024. And when the program is fully functioning, the maximum swing that an employer's account may have, either up or down, will be 15%, and that's an insurance calculation. To the WSIB is not looking to bankrupt an employer for in any 1 year. However, the staging of the program has been delayed. Interestingly, the WSIB is charging employers who received a premium decrease transition costs. So they're charging employers a nominal fee to pay for the transition cost of the program. I had occasion to look into that for a client because they saw the transition cost, and when I phoned the WSIB, they said, "Oh yes, that only applies to employers who got a decrease and are paying less than they would otherwise pay. Anybody who's paying more doesn't have that extra fee. So it's a fee for doing well." That's the way we like to look at it. Next slide, please. I'm going to change gears a little bit and talk about an interesting case that came out of the Ontario Divisional Court in August of 2021 called Morningstar versus the Workplace Safety and Insurance Appeals Tribunal. Under the workers' compensation legislation, workers are barred from suing their employers for any harm that would entitle them to benefits under the Workplace Safety and Insurance Act, or workers' compensation benefits. This is referred to as the historic trade-off. Employers fully fund the workers' compensation system right across the country, and in exchange for that, workers are barred from suing their own employer and their coworkers for any reason related to that injury. Their option is to claim for workers' compensation benefits. The historic position of the appeals tribunal when these types of issues have come up is that damages arising from wrongful dismissal are not barred. So workers have not been barred from bringing civil actions against their employer for wrongful dismissal cases where actions being brought that were related to personal injury have been barred. And that is consistent with the application of the Workplace Safety and Insurance Act. If we can get the next slide, please. In this particular case, a worker had brought a civil action against their employer, alleging workplace harassment and the employer's inadequate response that resulted in their position, resulted in their constructive dismissal. They felt that they were no longer able to work at the workplace and they stopped working. The worker sued the employer for damages under various headings. They sued for the tort of harassment, constructive dismissal, lost wages, and as well as aggravated, moral, and punitive damages in relation to alleged breaches of the Occupational Health and Safety Act and the Employment Standards Act. As is allowed by the Workplace Safety and Insurance Act, the employer brought an application to the Workplace Safety and Insurance Appeals Tribunal, arguing that the worker's right to sue was taken away. The employer's argument was essentially that the worker's civil action was a claim for benefits and it should be barred. The tribunal looked at the evidence and in that case determined that the worker's action was barred on the basis that it was a claim for injury for which benefits are available under the Workplace Safety and Insurance Act. On that basis, the worker was not able to proceed with any part of their civil claim, and their option was to claim for benefits under the Workplace Safety and Insurance Act. If I could get the next slide, please. The worker requested a reconsideration of that decision to the appeals tribunal. And for anyone who works in this realm, you'll know that a reconsideration is no small feat on its own. The appeals tribunal is only able to reconsider decisions in certain circumstances. First of all, you have to meet a threshold test in order for that to happen. You have to show that there was some error of law or misapplication of policy, for example. In this case, the tribunal did allow a reconsideration, did review the facts again, and upheld the prior decision and said no. The worker's claim, the worker's civil action was essentially a claim for benefits. The facts of the civil action are basically inextricably linked to the workplace or the alleged workplace injury for which benefits are payable under the Act, and the worker was not permitted to proceed with the civil action. The worker then applied for a judicial review at the Ontario Divisional Court. And while most decisions, generally decisions of the Workplace Safety and Insurance Appeals Tribunal, are not open to be reviewed in court, a judicial review is requested on the basis of an error of law. If I could get the next slide, please. What was significant about the two initial decisions, both the initial decision at the appeals tribunal and the reconsideration decision, is that they essentially represented a big win for employers as they set a precedent for being able to bar actions for constructive and wrongful dismissal if they were brought along with a claim for personal injury, for which a person could claim for benefits under the Workplace Safety and Insurance Act. It was essentially a one-stop shop saying that anything related to a claim for personal injury should be barred. The matter was heard by the divisional court, and the divisional court overturned the previous decisions. Interestingly, the worker conceded at the divisional court that the prior decisions were correct in that they properly barred the original claims that were related to the injury and including the tort of harassment and lost wages. So the worker agreed that they wouldn't be able to bring an action for the tort of harassment, for alleged breaches of the Occupational Health and Safety Act, and for lost wages related to the medical treatment for those issues. The divisional court said that the tribunal erred and erred when they barred the claim for constructive dismissal as well as aggravated moral and punitive damages. The court looked at the provisions of the Workplace Safety and Insurance Act, applicable WSIB policy. It examined the purpose of the relevant sections of the act and prior tribunal case law, which had allowed those types of claims to proceed while barring the portions that related to personal injury. And the court said that in this particular case, that not all of the workers' claims should have been barred. So the court agreed and partially quashed the WSIA's decision. Can I get the next slide, please? There are a number of highlights of the case. It's important to note that the court said that it's actually the job of the tribunal to root out civil cases that are actually claims for injury that are disguised as something else. So it is the job of the appeals tribunal to look at that. And when a civil action is related to a personal injury or does have a personal injury element to it, you do need to look at whether this is in fact a claim for a personal injury for which a person can claim for benefits. If they are able to, if it is a claim for personal injury, then that is the route that they need to go to. As long as the plaintiff doesn't sue in constructive dismissal in order to get around the limitations of the act, then that portion of the claim should be allowed to proceed. Can I get the next slide, please? The court said that it was important to make sure that the historic trade-off, and they referred to that historic trade-off and the inability to sue for personal injury, was not undermined by attempts to bring those actions for workplace injuries, disguising them as other things. And there were a couple of lessons to be learned from Morningstar, which we'll see on the next slide. Number one, actions for constructive or wrongful dismissal may not be barred by the Workplace Safety and Insurance Act. But it's important, if you do receive a statement of claim, to consider the nature of the action. What is actually being claimed and how is it being claimed? What's the wording of the statement of claim? Section 31 applications under the Workplace Safety and Insurance Act to bar civil actions may still be helpful and should still be considered, because the appeals tribunal can, at the very least, help pare down an action from what's originally being claimed by the statement of claim, and as well, a court can be bound by the tribunal's decision if it does proceed, and the worker would not be able to proceed with their entire claim. So there are a few interesting lessons from Morningstar, and if you do receive a statement of claim, it is encouraged that you do review it and consider bringing an application under the Section 31 in order to see if the action can be barred. I'll now turn the mic over to Richard for a Western update.
Thank you, David. The next slide. So the first thing I wanted to talk about was a consultation that's going on in British Columbia regarding workplace status. So we heard earlier about different workplace statuses: owner, employer, worker. There's also prime contractor and supervisor potentially. And in British Columbia, unlike some other jurisdictions, there's this other intermediate status called labor contractor. And where we see labor contractors used to determine status is things like the gig economy, sole workers who, or sole contractors who don't engage other workers who, and we see it in forestry, we see it in construction and the gig economy. Now, there are concerns with that status, particularly in construction and forestry, where those contractors aren't able to obtain work if they can't obtain insurance through workers' compensation. And so it's being re-examined in that light. Originally, the consultation was to close in the next couple of days, but it's been extended till January 10th, 2022 to provide people with time to consider and provide feedback. Next slide. So labor contractor status is an intermediate status, which allows registration of contractors who would otherwise be deemed workers if they meet certain criteria, providing major revenue producing equipment or contracting simultaneously with multiple firms. The proposed changes would do away with the specific criteria set out in the workers' compensation policy and harmonize it with the test used, the common law test for employment status, or also the test used by the CRA, for example, or in some other jurisdictions for workers' compensation. So this should address consideration for the specific criteria. One thing we often see is that contractors in BC who aren't contracting with multiple companies are deemed workers, despite otherwise meeting the test for independent firm status. And WorkSafe BC is looking to move away from that and apply the criteria that we see used elsewhere. And this change will also include a due diligence defense for employers. So if they've done the due diligence in contracting and setting up and determining status for contractors, they should be able to claim due diligence and not be liable for penalties or premiums associated with someone who's then later on determined to be a different status. So that's something to consider and participate in if you work in either forestry, construction, and the gig economy in British Columbia. Next slide. Another interesting thing that's come out is the changes to the regulations this September regarding safety headgear. Now, this is a change that was brought about by requests by the Sikh community in British Columbia and concerns that the current regulations or the previous regulations were discriminatory. And this change was requested by the Ministry of Labour of WorkSafe BC instead of WorkSafe BC examining its own policies. The change removed the absolute requirement for safety headgear, instead instituted consideration for the hierarchy of controls to consider whether safety issues regarding head injury could be addressed in other ways rather than the blanket requirement for safety headgear. What this requires is that employers assess each area of the job site to determine the level of risk of head injury. And so consideration, risk assessment prior to engaging in work that may result in head injury. Next slide. So most employers now, particularly with COVID, are familiar with the hierarchy of controls. Elimination, we've seen it with remote work rather than working the work site. Engineering controls such as plexiglass or other barriers instituted to protect workers. And then administrative controls, social distancing, things like that, or PPE masks, things like that. This is similar for safety headgear, where safety headgear, hard hats, things like that are the PPE. And so employers are now required to go through the hierarchy of controls and consider, we've identified a risk, workers working above others that may result in a head injury if they drop tools or equipment. How can we address this? Ensuring that work isn't performed below, instituting barriers, other guards as engineering controls. And those things have to be addressed and considered before requiring safety headgear in all instances. So it's important to go through that process to do the risk assessment before engaging in the work in British Columbia, but also raises interesting human rights concerns. So next slide, please. So previously there might have been a blanket there was a blanket prohibition against there's a blanket requirement for wearing safety headgear. And so employers didn't necessarily have to engage in the human rights accommodation process. We've heard about the accommodation process for vaccination, and it's similar for the safety headgear. Employers who don't go through the risk assessment, don't properly consider what other things could be done to address head injuries rather than requirement for hard hats, may face issues under not only workers' compensation, occupational health and safety legislation, but also the Human Rights Code and the need to accommodate employees. What they really need to consider is the balance between the safety risks where headgear is required and the religious beliefs of employees whose religious beliefs may prevent them from wearing traditional safety headgear. Next slide. The last thing I wanted to talk about was a recent case regarding regulatory violations in British Columbia and potential regulatory offenses. In British Columbia, like many other jurisdictions, there's different levels of different ways that the occupational health and safety regime can penalize or fine an employer for health and safety violations. We have administrative penalties, which are monetary fines. There's regulatory offenses, which are quasi-criminal in nature, and criminal offenses under the criminal code. Although criminal negligence and regulatory offenses are rare, we've seen an increase in them since the sawmill incidents in British Columbia in 2012. The next slide. So recently in November, there was a case, Regina and Brian Baker, Randolph Cossack, Yoho Resources, and Great Northern Bridge Works, where a worker died after he fell off a bridge that was under construction. And WorkSafe BC found in their investigation that the employer and prime contractor had failed to ensure health and safety of its workers. There wasn't any fall equipment or fall restraint devices used. The investigation determined that charges should be laid as a regulatory offense under the Act. Now, regulatory offenses can have penalties, significant penalties that aren't tied to payroll in the same way that administrative penalties are. So you see sometimes with very small employers, small contractors, that despite significant violations, the penalties are quite small based on their small payroll. But with regulatory offenses, you can have fines of up to $750,000 in British Columbia, or $743,000 for a first offense, and jail time of up to 6 months. For a repeat offense, you can have fines of up to $1.4 million. So significant penalties, even for relatively small employers, and the threat of prison up to 12 months for a repeat offense. There's also additional remedial powers that can occur with sentencing. Next slide. So in this case, there was a guilty plea, and this is something that affected the prime contractor, the employer, and the supervisors at the site. So the prime contractor was fined $70,000. The employer was fined $70,000. All of these included as well a victim surcharge. But also the individuals involved, the foreman and the site supervisor, were fined and ordered to participate in health and safety courses. So this is something where we're seeing penalties not only for the corporations, but also the individuals involved in the offense. All of these things were for charges relating to failure to ensure the health and safety of the worker and to institute health and safety practices and equipment regarding fall protection. Now, it's important to note that if a regulator is considering a regulatory offense or even criminal charges, they need to notify you that they're considering those, because their ability to compel testimony changes. So if you are ever notified that a regulator is considering regulatory offense or criminal charges, it's very important to immediately speak with counsel. Thank you. I'm now going to turn it over for question and answer period.
Thanks very much, Richard, for that update. We're going to use the remaining time just to answer a couple of questions. And not surprisingly, the first one is with respect to COVID-19 vaccination. So I think, Shane, this will be a question for you. And the question is, why are all of the mandatory vaccination cases from unionized workplaces?
Yeah, good question. I think of two reasons. One, a union can challenge a workplace rule or policy as unreasonable even before someone has been adversely impacted. A non-union employee, their most obvious challenge is around the time they're impacted by the policy. So when they're terminated or they're placed on leave. Also, the grievance procedure under a collective agreement can usually get a matter to a hearing more quickly than a civil proceeding. So you could get to a grievance arbitration in a few weeks or months, whereas a wrongful dismissal in a human rights matter move more slowly.
Thanks, Shane. I think we've probably got time for one more. We've had some interest in what Roz was speaking about with respect to regulatory enforcement. So Roz, this question is for you. It's a fairly general one, wanting to know what your thoughts are about trends in enforcement.
Yeah, no, that's a very good question. And I think that we've seen, certainly during the initial COVID period, there was a bit of a slowdown in terms of enforcement, which is not surprising because inspectors, investigators were having a difficult time going out to site, interviewing people, and obviously everyone's efforts were directed elsewhere. They also had the benefit, however, of a suspension on limitation periods in terms of their charging. So during that period of COVID for 6 months between March of 2020 and September of 2020, the legislature in Ontario suspended limitation periods also for regulators. So in many cases, the typical limitation period for laying charges was extended. And so what we saw, interestingly, was a couple of months ago, there was quite an onslaught of charges being laid all within the same 2-week period as the ministry worked its way through the process of having completed investigations and looking to see what they wanted to do in terms of charges and realizing they were bumping up against even the extended limitation period. So in terms of trends, that's a long way of saying that we don't have a lot of data in the last year and a half in terms of trends, although there have been a number of pleas and fines imposed. But I think we're going to see a lot more of that in the coming year as all of these cases that were backlogged through the system start to work their way through the courts, which are also backlogged right now. And then we'll start to see more of an indication of where things are going. But definitely there's been an uptick in terms of the fines in relation to incidents compared to previous years. And we'll have to see where that goes in the coming years.
Perfect. Thanks, Roz. I see we're right on time. Shane, can I pass it back to you for some final closing remarks?
Of course. Thanks, Cathy. And thank you to all of my panelists and to each of you for joining us today. And we hope to see you at our next webinar. Thank you again. If you have questions, you can reach out to us. We have our contact information on the slide here.